I'd like to introduce Michael Blinkoff. He is a real estate and title attorney with Blinkoff and Blinkoff in Buffalo, New York. He's earned his BA at Hamilton College and his JD from the State University of New York at Buffalo Law School. He's a member of the New York State Bar Association and the Erie County Bar Association. He served on the Erie County Bar Association Real Property Committee and actually chair for a period of time. Also 8th District Representative to the Real Estate Executive Committee and a member of the New York State Bar Association. Joining him is Francis Carroll. He's a regional counsel for Fidelity National Title Group in their Buffalo office. Graduate of Lemoyne College, received his JD from the State University of New York at Buffalo School of Law. He's held a number of senior claims and underwriting positions with companies that now are part of the Fidelity National Title Group, as well as holding a managerial position with a large title agent. So, gentlemen, I'll turn it over to you, whoever wants to go first.
Morning, everybody. I've been in the title business for almost 30 years, and working for a title insurer, real estate litigation is a considerable part of my working life. And over the years, we've seen all kinds of claims. And focus on our presentation today's use of experts in real estate litigation. Most of the presentation is going to be given by Mike, who's in the trenches on a lot of these transactions. And we've worked together for many years. I still remember it was more than 25 years ago when Mike and I worked on the first case together, where our company actually reached out to retain him as an expert. And he was kind of puzzled by the fact that we're reaching out to him because he was, at the time, he was doing some title work for a competitor, and he said, why would you use a competitor for something like this? And what I said to him was, it really doesn't matter with whom you're doing business. What we need here in this case is someone who can articulate the problems we're facing in this litigation and put forth our point of view in the case. And we were ultimately successful in the case. It was easement litigation involving some questions of the creation of an easement and its continuing viability over a period of years. And Mike did a very successful job for us in that case. And over the years, we get all kinds of questions about real estate litigation of various kinds, and it could range from anything from someone who's handling a personal injury case, either from the plaintiff's side or the defendant's side. And if you're on the plaintiff's side, it's important for you to be able to prove that you're suing the right people in that case. And sometimes it takes a real estate expert to articulate the fact of ownership, use, and control of a piece of property. Same on the defense side. I know one case that Mike worked on. I had first done an initial review on it, and I don't act as an expert witness in cases, and Mike got involved to help a law firm prepare for motion for summary judgment. It was a case over an injury that happened on a certain premises, and because it was a broken ankle case, somebody fell on some railroad tracks that were on this property. And since it was railroad tracks, you sue everybody, so they sued the railroad. And it was up to Mike really to determine ownership of that premises to help the defendant demonstrate this was not our property, this was not our fault. And his client prevailed in a motion for summary judgment. There are other kind of cases where an expert could be of very good use. We sometimes hear from lawyers who are defending attorneys in professional malpractice cases. And the key issue becomes, what is the standard of practice in a community? What need a lawyer do to effectively represent a client? And sometimes there's some very close questions about what is acceptable practice in a particular area. Now, if you're involved in a community, it's very hard to defend a case and say, well, my client didn't commit malpractice because everyone blows statutes in this community. Well, you're not going to get very far with an expert in that setting. But sometimes, particularly dealing with technical issues involving real estate conveyancing, it's important to have an expert on your side to make out your case. Now, our focus today is going to be on title litigation. And just some cautionary notes of some of the cases what we've seen. I remember early on, I don't remember what I had for breakfast this morning, but I remember these obscure cases from 30 years ago. One of our insureds was sued in a case where the plaintiff thought he had this claim to a 20-foot strip of our insured's property. And the client went to his attorney with a series of maps. Some of them were surveys that were 50 years old that seemed to indicate at some point in time some course in a description might have been dropped or misinterpreted, and thus this plaintiff thought that he had a good claim to this 20-foot strip. So the attorney said, well, that sounds reasonable. Give me a $750 retainer and we'll, bring on the case. And this plaintiff's attorney was a reasonable gentleman. He was a good lawyer, good general practitioner, but he didn't think through the case in any way. He took his client's position at face value. And in that particular case, had he done a little bit of research and hired an expert to help him examine the evidence, he probably would have decided, I don't have a case here. So there were some factual issues involved. The case went on. There were depositions. Clients are notoriously ineffective when it comes to proving a title case because they just don't know anything about the law, the background interpretation of documents. All they know is what they think and what they feel. So because of the factual issues involved, we couldn't get through a summary judgment motion, and this thing was going up to trial. And we were in front of a judge who was trying to pre-try the case and maybe dispose of it, and he says, is there any opportunity to settle here? Now, this plaintiff's attorney had never gotten an expert. He was basically going to go in and try this case based upon his client's own testimony and try to, present a number of different old surveys as evidence. And he had nothing. So when the judge said, is there any chance to settle the case? He said, well, yeah, if you pay us X number of dollars. Well, the X number of dollars he demanded exceeded the face amount of the insurance policy that we had issued to the defendant. So there was really no way to settle. And I think the attorney's presumption here is, well, this thing might work itself out. And I think he approached the case as if it was a typical negligence case that came in the door that you knew you might have been getting a third of the recovery as your fee. And basically this attorney ended up not having squarely presented what it was going to cost to his client. He ended up litigating this case right up to the verge of trial for $750. Ultimately, I think we paid about $2,000 to settle the case, but it just wasn't a good case from the start. Now, sometimes too in these cases that not only do you need an expert to evaluate your evidence before you go in and start a case, I would recommend sometimes, say this a little facetiously, having your client fill out a Moody's personality profile before you bring these cases, because in this particular case, the plaintiff was just a nut. He had a notion and he wanted to put that forward, but his real victim in this case, I think, was his own attorney, who ended up going through and going through the whole process and not getting paid very much for what he did. Now, my final comment with regard to experts is this stuff is very technical, particularly in a title case. You might be dealing with chain of title, legal descriptions, interpretation of surveys, and even though our materials here are under tab 2, and on the second page there are 2 statutes from the CPLR that talks about what kind of things are admissible in evidence. A title search done by a licensed title company in New York can be admitted as evidence. Old maps and surveys and plats that are on file in the county clerk's office, these things can be readily admitted in evidence. But what do you do with them? I mean, you could go to John Ortendahl and have him do a nice title search, half an inch thick, nice crisp blue cover on it, and you go and hand it to the judge, and the judge looks at it and says, what am I going to do with this? Well, you have a survey done by a professional surveyor that lays out some stuff. How do you interpret that to the court? You really do need somebody who can effectively bring to the fore to the judge who's sitting on the case what this case is all about, what your client's position is all about, and furthermore, creating an effective record on appeal in the event you lose in the lower court and you have to take that case up. So with no further ado, I'm going to turn this matter over to my colleague, Mike Blinkoff, who's going to talk about some of the cases that he's been involved in.
morning. Thank you for having me. Beautiful facility here. I have not been down in Jamestown in years and had very little contact whatsoever with Jamestown, except that several years ago. But my okay. This? What's this? Oh, I'll do this.
Check, check.
Anyway, several years ago, what's the name of the rock group you guys have out of Jamestown? Fame, 10,000 Maniacs. Well, Teresa Drew was in my office and working with me, and her brother is in the group, or was in the group. And so we had a small collection matter for him. Somebody must have stiffed him on a concert. And I called Sandy Silverberg, who's an attorney in Buffalo. I don't suppose many of you know him, but if you did, you'd understand this. And I said, Mr. Silverberg, I said, it's Mike Blinkoff. I represent 10,000 Maniacs. And he said, wow, that's impressive. I stopped counting years ago at 200. True story. Let me tell you about what I'm going to do today. I'm going to talk about a few cases. I've got them in the materials that I've handled, okay? And then at the end, we'll have some fun. I may not get through all the cases, or I may get through them fast. I never know. It kind of depends on what I think I see out there. But the first thing, and Frank started to get to this, is when you are an expert in a title case, most of these cases get settled somewhere along the line, or usually summary judgment. Occasionally they go to court. I've only had 3 of them actually where I've testified at a trial in front of a judge. And I can tell you that the one thing about being an expert is that the judge sometimes doesn't like you there because he feels you're doing his job. You're interpreting what he's supposed to do. Is there an easement? Isn't there an easement? Where's the boundary line? Isn't that what I do as a judge? But generally speaking, most of the judges don't have a real estate background, and they prefer somebody who can help them along and tell them about the real estate issues. And that's what I find. And also, those cases, they're usually non-jury. So the judge says, look, let them talk, let them tell me, because it helps me. And if it's prejudicial, I can throw it out because there's no jury here. So the first case I want to talk about in your materials, it's called Empire Boulevard versus the County of Monroe, but really what we called it was the Back Hill case. That's just what it became known. And what Back Hill was about, I got a call from somebody in Monroe County, and they said, look, we want to make sure that what my client thinks he owns is what he owns, because the neighboring party says that that's not what he owns. And what he had,
Upside down.
you see how good that is?
Stand on your heads, everybody.
And what we had was a dispute between the owner of Lot 1 and the owner of Lot 2, okay? And the owner of Lot 2, which was our client, wanted to know, what is it that I own? Because this is what the surveyor shows, Lot 1, Lot 2. And this is what deed atlases show, and so on and things like that. And I said, well, that's easy. You go to the description, and let's see what the description says. And the description was very simple. The description's on page 5, and it says, it was all that tract or parcel of land situated in the town of Penfield, county of Monroe, state of New York. Well, that's easy. Known and distinguished as Lot number 2 of the first division of Township 13, containing 50 acres more or less. That was it. Lot 2. That's it. No meets, no bounds, nothing. Lot 2 of the first division of lots. I said, okay, that's not so hard. We just got to find the map that has the first division of lots, right? And very simple. So I call over to Monroe County, to the clerk's office and to a search company. I said, can you guys send me a copy of the first division of lots of Monroe? Because they've been using this description, because the neighbor had the exact same description with Lot 1. And so he said, sure. Calls me back 5 minutes later, and he goes, we don't have one. We don't have this map you're talking about. What are you talking about? He started asking me, like, what are you talking about, the first division lot? I said, look, this is in your legal descriptions. And I said, my clients had it for years. The neighbors had it for years. You got to have this map. And he said, no, they didn't have that map. Now, I don't know if you've ever found that before, but you find that in a lot of cases that some of the maps are so old, they just aren't there anymore. And so now the question is, what is the first division of lots and what map? And so the owner of lot 1 said, it's very simple. It's just what's shown on my survey. I own all of this, like that. You own, Mr. 2, you own all of this. You got half the waters of Irondequoit Bay or something like that. I got half, we're on there. And that's it. And he said, I've got deed atlases that were on file in the Monroe County Clerk's office that show this exact picture. This is what they show. And they show the names of the people from beforehand and so on. Well, the problem is, that's still not the map that they're all referring to. I mean, that's the immediate problem. And the other problem is, okay, we've got abstracts that we were given. And, it has that description, lot 1, lot 2. But the abstracts started around 1900. Now, I don't use 60-year searches here? Is that generally 50? Okay. Now, 50-year searches, that's a business decision you've made to use 50-year searches. Because you're saying that the stuff beyond 50 years maybe isn't that important, or it's things that I have to worry about. And that might be true in 90% of the cases. So it was very similar in Monroe. The searches they had were about 60 years. And I said, well, was there anything before that? And I sent the searcher on a mission, and he said, yeah, there's some deeds before this in the abstract. They go all the way back to the 1840s. He said, that's all I could find. And I said, well, if they're using the same description in the 1840s, then this map had to be before 1840. So all these things that people are using, from the county clerk's office at that time that came after, they really aren't relevant. We got to find that original map. So we went on a hunt. And, the internet's a wonderful thing. And, of course, through the internet and all this, I was able to find that in 1829, through the Surveyor General of New York, they'd done a map and laid out the boundaries. Well, read a deed from 1840s. That's pretty proximate to the 1829. Was probably the map they were talking about. Okay? And what do you think that the logic was? If you think about it, you know how that we were all laid out? We were laid out in parallelograms, and in 50 acres, meaning so many acres is that regular standard grid. It was a grid. So you go to the map, and when you go to this map that was on file in the Surveyor General's archives, you find this. That guy owns all the waterfront. Wow. Do you realize what that's worth by compared to being, you think lot 1 was happy? This was not a happy guy. So on a summary judgment motion, we went in and we said, there you go. This is what we own because the true division is right here because the most proximate map we found was that it had to be the first layout of those lots, even though, now here's the problem, it's not in the county clerk's office. Now what you remember Frank just mentioned to you, the statute that says if it's in the county clerk's office, and that's really what it says if you read that statute, it doesn't say you can find it somewhere else. If it's in the county clerk's office, it's admissible in evidence. If it's not in the county clerk's office and kept as one of their records, it's not admissible by itself. But this is where I come in. See, I'm the so-called expert. And I prepared an affidavit and testified and said, look, I'm a title examiner. I know that I can rely on certain things, like the proximity of a deed to a map versus later maps that have no reference. I can come to the conclusion that this is what they intended because the ultimate answer to that question is what was the grantor's intent at the time it was created. Grantor's intent is virtually the answer to all the title questions. It really is. And that had to be the grantor's intent because that was the only lot division that existed at that time. And so, the judge said, and I've got his decision here, He went, first of all, on page 17, I've got part of his decision, which is important. He said, Summerhays, who was the opponents, used surveys. You know, they like surveys, and surveyor said, oh, no, this is what's, you know, this is like occupational. They'll do occupational all you want. That doesn't necessarily mean it's legal title. And we'll talk about that in a minute. But by his own admission, the surveyor admits he does not examine title or give title opinions. He didn't conduct any title examinations. You got to remember that. There's different people here, surveyors versus title examiners. Mr. Blinkoff, I love this case because I come out so good. Mr. Blinkoff, on the other hand, certainly did that. And I find that the foundation for his expert opinion fully meets the burden. And then he says, an objection has been raised to the admissibility of an 1829 map because it's not on file in the Erie County Clerk's office. But the map has been referred to in the deeds, which are in the chain of title. See, he really understood. This judge understood exactly what I was saying. They are referred to in the Blinkoff affidavit, and it appears to be the kind of evidence which in the ordinary course is considered reliable by people who, or should I say title examiners such as Mr. Blinkoff, informing an expert opinion. Although it may not be admissible in and of itself, it is the kind of evidence that Mr. Blinkoff, as an expert, has a right to rely on in forming his opinion. So, happy client, waterfront property, back hill is his. Okay. That's it. You've seen my artwork for the day. And I will move on to another case. Brahaney versus Owens. Very similar. You're going to find, like I said, the grantor's intent is what controls almost all these cases, and it's somewhat similar. And in Brahaney, page 21, it starts in 22. Yeah, 22 is the abstract first set out. It's actually the first set out. And what it is in Brahaney versus Owens is that Mr. Owens built a golf course, and Mr. Brahaney felt that the difficult par 4 17 was on his property, not on Mr. Owens' property. So Mr. Owens put his golf course partially on Mr. Brahaney's land, or at least so Mr. Brahaney thought. And Mr. Owens, of course, had surveys that showed where, you know, the occupational lines and all this sort of stuff, and why his golf course was properly located. But you go back to the same question. Here's my abstracted title, first page. That's on page 22. It tells you exactly the size and what they're giving. And in the abstract, and here we go again, the abstract was not a full abstract. It was from, I believe this was Wyoming County, which you guys, anybody here from Wyoming County? No, but about 60 years. I think they used 60, 40 years, one or the other. And it didn't have the for title. So the question is, what is Mr. Brahaney, what does he legally own? What is his legal description? Well, I gave you on page 23 the fact that I called somebody at Tycor back then, and I said, hey, can you guys go back again? Go before the abstract, so that I can see the whole history of this property. And it was interesting that I never realized Wyoming County was part of Genesee County. So some of the deeds were filed in Genesee County. And he got them for me. And on page 24, what was really great was that in that time, when they used to do these old deeds and Holland Land Company was whacking up the Western New York and giving pieces to everybody, rather than write out sometimes the long legal descriptions, they drew them. They drew little pictures. You won't find that in the later deeds, but there it was. There was a picture of exactly what was being conveyed to my client's predecessors, and it was a rectangle. And it was a perfect rectangle, met exactly what my client thought he owned, and included part of the golf course, because the neighbor had relied on occupational surveys. And you can see on page 25, when it got down the deed after, it was the only picture. And there it was. It was beautiful. I mean, it was the exact measurements, the perfect rectangle. And what I've given you on page 26 is something that I use almost all the time. It's a quote from Owen Mangan, because most of your disputes are the difference between legal title and occupational title. And once you have legal title, then you get all the hard time of showing that you own any part of my property through your occupation, because you got to go into all those doctrines that you need to bring in. And let me tell you, if your deed, like in this, is unambiguous and can be determined from the four corners of the document what it is you own, then you don't have any rights to use parole evidence. And you got to really work hard to try and bring in other doctrines like adverse possession and things like that, because the legal title is established. The document is, if the document is ambiguous, then you open the door to anything, you know. Then you get in these, you know, what do you like to call them? Boundary by acquiescence, practical location. They all have adverse possession, prescriptive. You can hear, you know, all this stuff. But if it's not, then you got some issues, because you're going to say, wait a minute, my legal title's clear. The grantor's intent is shown. This is what's been. And this is the same parcel, in fact, from the Holland Land Company that my client still had title to. That hadn't, description hadn't changed in 150 years. The judge sure wasn't going to change it. And so on page 26, I give you, in the middle of the page, just a quote that I use all the time. It comes from Owen Mangan. Anybody knows a predecessor of counsel to Tykor. And he said, occasionally a surveyor will assert that the monuments he found in his fieldwork override the legal descriptions in the deed. However, and I love this line, the survey does not create a title. Title to land is evidenced by the chain of title in whatever form. The survey can identify the record monumentations and locations, but the quantum of the title depends upon the chain of title. And really what he's saying is it's the quality of the title that matters when we examine it. And let me just step aside for a minute and give you, I got time, a brief example of that. One time I was on the stand, and I was being cross-examined, and they were hammering me about the fact that my person I was testifying in favor of had a history of quitclaim deeds conveying the property. And the lawyer kept saying, Mr. Blinkoff, my client has warranty deeds. Your client has quitclaim deeds. You can't tell this court that quitclaim deeds convey anywhere near the quality of a title of a warranty deed. And of course the judge looked down at me and goes, he's got you there, doesn't he? And you know, because they tend to do that sometimes. And finally I said, Your Honor, may I explain? He says, well, I wish you would. And I said, let me put it to you this way. I'll give you a warranty deed to the Brooklyn Bridge or a quitclaim deed to my house on Depew Avenue in Buffalo. Which one do you think gives you better title to something? And he said, I see. I said, the quality of the title is not determined by the instrument. Now, that's just stepping aside. Let me go through now the decision as to the Brahaney case, because it's important. The decision starts on page 27. And what the judge said, if you look at page 28, letter C, he says, as explained by plaintiff's expert Michael Blinkoff, during his testimony, the description of plaintiff's premises has remained intact for well over a century, and the description of said premises is very clear and without any ambiguity. See, he understood it. He understood it. As Mr. Blinkoff further testified, that defendant Owen's property is clearly described in their deed. These premises do not overlap. Now, you had a lot of surveys that showed all this overlap because they had occupied it. They had done it differently. They had had different beginning points. But the real location of the legal titles were absolutely clear. Now, the important part of this as well is on the next page, 29, the conclusions of law, where in number 2, a judge said the defendant, Robert Owens and Connie Owens, have failed to properly raise any claim of adverse possession. Here's the problem, and you better know this if you do any of this litigation. Adverse possession is an affirmative defense. If you don't plead it, you lose it. So when my guy says, and brings an action and says, we own that part of the golf course, it was up to the defendant to then say, no, I've done this with that property, you know what the rules are, right? Open, hostile, continuous, claim a right, did I close it off, all that kind of stuff. You don't plead it, you lose it. And so my client wins. How do you think that ended after that suit? Does the word malpractice come to mind? You see, because it wasn't pled, and because the judge said that, the lawyer who represented the defendant, who's a great guy, and I've known him for years, was sued for malpractice. And that case went on and on. And let me tell you something strange. They called me as an expert in that case. And you know why? Can you figure why? Because they wanted me to say, which I was willing to say, that I had such a good case that no matter what the hell he did, he was going to lose. He could have raised anything he wanted to. So I gave that affidavit. And eventually what happened? On summary judgment motion, the lawyer was found not to having committed a malpractice. In fact, they said it really was his judgment call to realize that he did not have enough of the elements of adverse possession, and a mistaken judgment is not considered malpractice. And he just decided, and fairly so, because, you know, as I said, I'd gone through transcripts, and there really wasn't much of an adverse possession claim. Other than, you know, yeah, he built the golf course, but it wasn't there for statutory time. And then there's a question of, did he have, really, if his legal description is so clear, do you really have any claim of right? You have to have claim of right. You have to have color of title. Remember that color of title word? That's like a part of what you need in adverse possession. And he didn't have it on the neighbor. Now, do I think if you were defending that lawsuit, should you have raised adverse possession? Oh, yeah, you raise every damn thing you can, because you know how lawsuits work, and along the way, you know, questions, he's got some chance, maybe this much of a chance, but, you know, we don't want to take it, maybe we'll settle, maybe we'll, you know, split the baby down the middle, something. But when you don't plead it, then you lost it all. Okay. The last case that I have to talk to you about, Cook versus Kenny. Now you got to go through this with me. Turn to page 31. This is a survey of Hunt Avenue, Riverside section of Buffalo, New York. I realize you may not be familiar with that, but it's a typical city section built many, many years ago. Everything's close together, you know. Everybody's driving over everybody else's property a little bit. I imagine you got things like that here. It's very, very common. So anyway, you look at this survey and you see the house owner is 65, where his driveway starts. Obviously at the very beginning, if you look at the angle, there is in fact only about 4 feet, not enough to drive a car over. Now, your first question is, you know, you say, well, what did the lawyer tell his client? You know, and unfortunately, and this is what happens in a lot of these cases, the lawyer didn't tell his client anything about it. I mean, he just, you know, just didn't. And let me say this other thing to you. If you walked up to that property right now and looked at it, you'd never think that there's this problem, because you see a driveway, and it looks squarish, you know. You see the driveway, you see the neighbor, you know, driveway. There seems to be, you know, room, because that's the way it appears from the street. But when the survey's done, you realize that the lot line came in at an angle and deprived Mr. 65 of any ability to get back. And of course, what happens? I mean, do you think these happen between friendly neighbors? You think they were over one night discussing this, and she was having wine and said, I think you're driving over my property. Oh, that's okay. No, that's not what happened. What happened is the clown who owned this piece that had to drive over it decides one day he's going to moon his next door neighbor. It's true. It was in the testimony. They didn't get along, and he got mad at her, and he mooned her. And she said, well, that's it. And so she went to her, I hate to say this, free lawyer, and said, why does she have a free lawyer? Because, certain union legal plan. I don't want to get into it, but, there you go. Because nobody else would have said, they would have said, get out of my court. I'm not going to bring this. Too expensive. You don't want to do it. No, free lawyer. And he says, okay. He says, go. You can put up fence. Put a fence up right on the line. So she goes, files for a permit to get a fence. My guy hears about it and, boom, runs into court and at least gets a preliminary injunction hearing and then eventually a trial. And so the question is, what does he have? What does he have? What kind of a prescriptive easement? Now remember, when you bring these cases, a lot of times you got to file notice of dependency. So you got to talk about what property is being affected. So you had to get, you can't just say, well, I need part of the driveway. So we got an expert out there, surveyor. And on page, page 32, and I admit you got to turn this upside down maybe if you want to look at it. I don't know how you want to look at it, but that reminds me of once I was going to give one of these talks, and I was doing some work from National Fuel Land Department, and I said to the guys, I'm going to be talking to a lot of young lawyers tomorrow about surveys and what they see. Is there anything I should tell them? And the head of the land department, he says, yeah. He says, would you tell them that north is not always at the top of their desk? So anyway, this is, you see that triangle there, the dark triangle? That's what he needed. 3 feet at its widest part would give this guy vehicular access to his garage. Okay. Now here's how we presented the case. I was the expert for the guy the mooner. I was the expert. Joe Visby, I don't know if any of you know him, but he's well known. He was he's passed away, a well-known title man, was the witness for the other side. And the question is, did we establish a prescriptive easement? And the evidence we had, because this is an old part of the city. People are driving over this forever. And the evidence we had, we were able to locate, as you'll see on page 33, a 1944 survey that showed a garage and a driveway. What conclusion do you draw from that? I drew the conclusion as a title examiner. They asked me, Mr. Blinkoff, what conclusion do you draw? Why do you believe that as a title examiner you feel there's a prescriptive easement? And I said, well, I'm reviewing a 1944 survey. I see a garage and I see a driveway. And so I draw a logical conclusion that people at that time were driving their cars over this property, probably openly and with the requisites of prescription, or at least enough to get the case to where the burden would shift to the other side to tell me otherwise. And the next exhibit, 34, was the 1975 survey. So I said, look at that. Garage, driveway, Mr. Blinkoff, what do you logically conclude? I went through the same routine. Okay, and then of course there was today's survey, which showed the same thing. Now, when you see these cases in front of, and the judge was Judge DiTullio, who's outstanding. She's a wonderful, she's rated like highly qualified, which I suppose is one candidate once said, well, I'm the only candidate rated qualified. But she was rated highly qualified, and she is. She's an outstanding judge, and she knew what was going on. She looked at this, and she understood the whole thing. She said, this is Riverside. This is Buffalo. If I tell people that they can do this, and they could do this all over, all of us who do real estate deals are going to be in trouble because we're going to say, you've got no access or something like that. So she knew what was going on. And so she said, I found enough. She wrote a wonderful decision. And the decision is there. And she said, hey, there's a prescriptive easement. Now, interesting, I do have to tell you one of the things I did here. When I was on the stand, I mean, I showed how trivial this was, because what I did was I said, Judge, I said, do you realize the area that we're arguing about? And I took sheets of paper and I put on the floor, like 1, 2, 3. I said, that's the widest part. I said, the next one would be like this, you know, maybe 2. In other words, it gets narrower and narrower. I said, this is it, Judge. This is why we're in court. And so she understood. She said, this is trivial. This is important to this man, and she's got to get over being mooned, you know? And so the judge rendered this wonderful decision where she said, surveys of the property from 1944, 1950, we had another one, I couldn't find it, but in 1975, all depict the respective driveways at 61 and 65 Hunt Avenue and the existence of a garage in the rear of plaintiff's property. And then she said that on my testimony, it was reasonable and logical to conclude that plaintiff's predecessors in interest used a portion of defendant's driveway to access that garage from 1944 until the plaintiff purchased the property. It was like 50 years, 60 years later. So that was her conclusion, and she said it was notorious and continuous use in excess of the statutory period, giving rise to the presumption that the use was adverse. And once the presumption was there, the burden of proof shifts to the defendant, and the defendant had no proof otherwise. And really, how could they? What would the defendant have done? Brought in somebody from 1944 or 1950? They're dead. There's nobody around to testify. So she made that decision. What was their testimony? Their testimony, Joe Visby said, you don't know. He says, you can't conclude that they were driving to go to the garage. They might have done other things with their garage. They might have stored their bikes in there. They might have stored, come on, really? Really? No. No, until you get to the appellate division. Then you get to the appellate division, and they basically tell you on page 42 and 43 that I'm worthless. That's exactly what they said. I mean, and maybe it was a bit kind, I don't know, but they said, the expert's testimony presented by plaintiff failed to establish that plaintiff's predecessors in title used defendant's property for any purpose, adverse or otherwise. And the conclusions reached by plaintiff's expert with respect to the alleged prescriptive easement were based on mere speculation. I was useless. What'd you bring him in for? He just speculates. He didn't do anything. And so they denied the prescriptive easement. Now, how did he, again, this is another, this is a side criticism. How did this guy get to go all the way to the appellate division? Free lawyer. How could a driveway that leads to cars be merely a driveway that leads to a garage be merely speculative that people drove over it? I don't know. I don't have a good answer for you. That was the appellate division's decision.
So Mike, what happened on remitter?
Remitter, there was nothing to say anymore. They had already ruled. I mean, they basically said, yeah, we'll send it back for the judge to put it in, and the judgment was that, denied. No permanent injunction, no rights. Which I believe the way it ended was license fee. I think that's the way it ended. The mooner had to pay a license fee to the mooney, I guess, in order to use the driveway. All right, at this point, I hope you learned something. I always try to make sure, I always hope somebody learns something here. I usually get to the point where I want to have some fun because I feel like a lot of the stuff I talk about isn't all that exciting. So I'm going to do this with you. On page 45, these are just some of the things that I've collected through the years. Really, the greatest source of comedy is us. Honestly, we're hysterical, some of the things we do. But anyway, Exhibit H that I have there, which is on page 45, is an affidavit from none other than Frankie Devins. Does anybody remember that name? Nixon, Peabody,
Nixon
Devins,
Hargrave.
Doyle, Nixon, Hargrave, Devins, and Doyle. Yeah. And it comes from years ago. And it's an affidavit of heirship. You guys all know what affidavit of heirships are if you do title work and stuff, where you say, hey, look, we got to tell what happened to somebody because there's no good records. And most of the time we accept these self-serving affidavits. And here's what he said on page 46 at the top. At noon, on March the 7th, 1901, my said Uncle Franklin, then a partner of my Uncle Eugene Ashley, these were all lawyers, okay, in the law firm of Ashley & Ashley in the city of Lockport, closed his roll-top desk and mysteriously disappeared. Come on, how many of you wanted to do that? Mysteriously disappeared. He has never since been heard from, although extended and costly efforts were made to find some trace of him. I read that affidavit, and I just had one question. Did anybody look in the desk? Next thing I have for you is a recent affidavit that I found on New York state and federal estate tax. You know what I mean? Where you say, there's no estate tax, there's no U.S. tax, because, it wasn't big enough. So you look at line 2. It says, deponent is the husband of the late decedent. Okay, that's how she's establishing the facts that she's able to give this affidavit. She knows. She knows her husband. She knows his sources of income. And that, therefore, we can count on that. We can take that at her word. And then we read number 4. Deponent is familiar with decedent's estate because deponent is the mother of decedent. There's a law against that.
There's also a play. So
yeah. And it was notarized by Oedipus Rex. But the fact is, the people sign this. They shove it in front of them, they'll sign damn near anything. And we take them, and we file them. But, we're a funny group. The last thing I have for you is what I call the AKC title. This was sent to me many years ago by somebody in the Southern Tier. And what you're looking at on page 48 is, very simply, it's a deed. Brenda Strasser is making a conveyance to 3 parties, Betty Jean Miller, U.B. McMullen, and I forgot who the other one is, but 3 parties. They're all tenants in common. You know that, right? You know when you see a deed without any other indication, it resorts to being tenants in common. Well, then you read on page 50 a pretty fascinating affidavit by Brenda Strasser. That was the 3rd party who was entitled. And Brenda says, on page number 3, you will see the set out. It's part of a search, so you know I didn't make this up. It's part of a search. And then on page 51, you'll see Maureen McMullen's affidavit. And Maureen says, yeah, that deed. Yubi was my dog. So one of the tenants in common was a German Shepherd. And what's really fascinating as you read the entire affidavit is not only did the dog get the farm, the dog bought the farm. The dog is now deceased and is buried at Oak Hill Road. You got a deceased dog in title, you know what you got to do. You got to probate the estate. You got to go find the bitches and the sons of bitches, which is a perfectly correct use of the term. And don't you want to see the TP 584? Is there a paw print on that? How did you do that? How did you do that? It's recorded. These are libers and painted. Well, then, of course, the other 2 tenants in common quit claim out the premises in question, which, and I mean, the answer to that, if you really want the answer to that, a deed to a dog is void, and so you really didn't have to probate the estate. Although I'll bet somewhere there is a puppy running around who's got an interest in that property. Anyway, thank you very much. I enjoyed talking to you.
You know, one concluding remark about boundary line disputes, and they're the most hotly contested fights that you can ever see, and they run a continuum. Mike was dealing with one on a commercial piece of property that actually had some value, but generally minor overlaps and encroachments. The owners tend to take care of these in a very business-like fashion, get rid of it and move on. Becomes a little touchier when you're dealing with people's homes. But boy, when you get to vacation property, particularly on the waterfront, you know you're in for a battle royal. And I just recall some years ago, I saw a movie about the golfer Bobby Jones. It was a very interesting movie, and part of it was a few little scenes and clips that showed him practicing law. He was a practicing lawyer in Atlanta. And there was one scene where a couple came in to consult with him, and they wanted to sue somebody. And said, "We want you to sue Mike Blinkoff." And he said, "I really don't know if you have a case." So the man said to Mr. Jones, he said, "But he told me to go to hell." And, you know, Bobby Jones sat back and he said, "You know, you don't have to go there." So, thank you.